One of the common misunderstandings that people have about DUI law is that they think that the .08 is the legal limit, and that's really not an accurate way of describing it. You can be charged with the DUI if you have a BAC of .06. I had a case in Morgan Hill where the client was charged with a DUI with a BAC of .05. .07s are actually quite common. There are two code sections in Vehicle Code Section 23152, and I encourage you to read them. A Vehicle Code Section 23152 makes it against the law to drive under the influence of alcohol. Vehicle Code Section 23152B makes it against the law to drive with a BAC of .08 or higher. If you're driving with a BAC of .07, most police officers will consider that to be under the influence of alcohol, and they'll arrest you in most counties. However, it's very common in those situations for the DA, when you get to court, to offer you a wet reckless or even a lesser charge. If you're busted with a BAC of .06 or .05, I think you have a very good chance of getting a dry reckless or simply seeing the case dismissed. The case that I had at Morgan Hill where my client was charged with a .05, I really feel that was mischarged. I told the DA, he took a second look at it, he dropped the case. .06s, again, depending on the county that you're in, can be charged as a wet reckless. In some cases, I've even seen them charged as a standard DUI. But in almost every case where I've had a .06, in fact, the only cases where I've had a .06, we were either able to get those cases dismissed or negotiated a plea to a dry reckless, which is not a DUI. A dry reckless is just reckless driving. You pay a fine, there's 2 points on your driver's license, and you go home. Why the .08 second count? Why the the .08 second count is called the per se count. And by per se count, we mean that you are guilty of a DUI even if you're not under the influence of alcohol, if your blood alcohol concentration level is a .08 or higher. That's why there's that second count. And the reason why was, back in the old days when I first started practicing law, attorneys were able to get their clients off who had a .10 or even higher if they could demonstrate to a jury that their clients were alcoholics and therefore had a high tolerance for alcohol. And with a high tolerance for alcohol, they're not driving under the influence of alcohol. So the states decided to stop this from happening. All 50 states now have those two counts, the driving under the influence count, and then what's called the per se count, the .08 or higher. And it's the confusion of those two that causes a lot of people to misunderstand what the law is.